So we've been waiting a while, Your Honor, for this court case to be presented, bring to panel. Just wanted to bring note automatically without arbitrary power or influence, reversal in favor of the plaintiff becomes a must in this in all courts. Being provided H.R. Bill 4115, which with the original summons and complaint, as long as there is a cause of action listed and a statement saying that the defendant is liable under it. 1 and 2, which are both seen in the original complaint. This case automatically goes into discovery. That being said, any implication or alleged, or anything that's been stated or implied or not stated that is now stated has to be taken as fact and truth along with everything else to test the legal sufficiency of the complaint. That has been the way it's set. Things I put above you are the beginning paperwork to the City of Kalamazoo. This is us having verbals and all contact and connections with every single artist that is listed. Smile Festival, so I get to do what I want with it, or however I want, or sell however I want it, because I am the source. This is where the defendant put perjury, claiming they never used the word scam at all. They did it multiple times over multiple facets, knew they did and already lost, so they just chose to deny, and lie. Those statements to your left. Also, a reasonable person took that as true, as you see all the people on Facebook in there. Which there's reckless disregard for whether or not the statement was true or false, which constitutes actual malice, which was also stated by the defendant. And there's negligence, though it's not necessary to prove. We made sure to prove negligence also. So there's no argument, and there are no further grounds or argument between the perjury and the confusion they've caused the court. We put in a motion denied, motion delayed, and it got denied because we were going to have resolution, because obviously the courts can see that this is the case and what's going on. This is how that was protruded on commercials and reports. We're literally staying outside WT8. Called me earlier saying my festival is fake and all of it's fake, or it's a scam. It's definitely not. Got my backpack, all my paperwork, everything in there. No answer. We'll see what happens. The public, heeding them not to take part in business, which damaged my business and reputation for both my business and myself. Those damages are also being sought after, especially with them avoiding or trying to avoid settlement and lying and saying they never used the word scam at all, to deny the whole entire event, rather than having to pay damages because there is no other outcome or no further outcome, especially due with the extreme amount of evidence on the plaintiff's part, including what is being portrayed to you now. Those spoken or written statements of defamation are being produced to you guys now, including the way that it was set up on the WT8 screen, the warnings and alerts that were never spoken, said, or portrayed to the media, and the fact that there's conversations between the owners and the people I do business with, coming down the line saying that WT8 is the perpetrator of the word scam and who portrayed this as a scam. Coming into the next part of this, me losing sponsors because of WT8 going up and telling them that they have a scam or a possible scam, or bringing the word scam into play with my festival, after being in touch with them and having my paperwork and having them look over that, and being in prior contact with them for a few other things prior to this festival, made it so they'd have to drop liability and deny themselves, and also being in contact with the homeowner with those text messages also provided in the original complaint prior to this report being aired. Her saying I just need something to say I could afford it before this story was aired, and me relaying that message, and them continuing with a reckless disregard for the truth, or for whether or not the statement was true or false, which constitutes actual malice, and awards meet damages in any matter of the law, and this is truth and fact, and all statements are truth and fact. Make it so I can get compensation for the things that they have done. Also, keeping track of US 26 code 8382 limitation on net loss forward. You have to keep track of everything that's going on in your business and all of the business losses that you've experienced, all along with the provided proof that you were going through these business endeavors prior to the court case. We submitted that on the first date of any court action, that investment in that business losses and business projects. We kept the numbers, we kept the tab rolling until this was either settled upon or paid for, and it's come to a pretty costly price with the expenses and everything that's necessary to have to pay for, or that have been paid for, taken account for. This is more than more than justified, and has to be paid as a legal must, given rule of law, which has three components: that is held equally, that the law of the land and the state and the Constitution are provided, and then that those laws that are provided are held with absolute supremacy. So those are the laws in the final law, absent of arbitrary power. So that's somebody doing anything they want to just because they feel like it, or outside influence, somebody getting bribed or having to go through another process. Back there, you saw that the implications alleged, or the allegations alleged, if not implied, have to be taken as true in fact, even the ones that are implied. So what I say is true or fact. There are also multiple grounds for this appeal, buys if there was any, for those rules to get missed. Makes my end or my side or the plaintiff side feel like there's some type of bias, whether that be because I'm parapro or whatever is going on in the situation. That's seen. Also, the ineffective assistance. I'm an athlete, entrepreneur. I'm not trained in legal or ordinary law, or I was not trained in legal and ordinary law at the time. Now I'm a pro per. So the ineffective counsel plays a role and is grounds for an appeal or a reverse order as a must. There are a few others in their error during the submission of evidence. The judge took their evidence, their exhibit, and not the plaintiff's. The plaintiff's was the written defamation itself, which would have ended this case a long time ago, and I think that's super important. So those be the reasons. I also have something I would like to read off to you, and that would be the end. Your Honor, I'm sure you're familiar with the briefings and the court rules, HR bills, and sub-rules that come into play. Also, the fact of legal sufficiency tested and taken as true and fact for the plaintiff, in order to test that legal sufficiency, in order to give us a true handle on the complaint. That being said, those flags and allegations alleged have to be taken as true and fact also. Sub-rule C8 is false and failing, has always been false and failing, to which it can only be granted as evidence is so clearly unenforceable by a matter of law that no factual development can be justified. That is not the case. It's false and failing in every matter of the law in this case. With evidence and word of law, word of the Constitution, and new HR bills, and U.S. codes provided, must be upheld as arbitrary power, absent of outside influence, or has to be held with absolute supremacy, absent arbitrary power and outside influence. So these are the things that we have to go off of and go forward with as legal standard is set respectfully as a must. We did the order for justice delayed, and it got denied, saying that there would be remedy. That kind of gave us headspace, so we're happy about that. The perjury leaves no grounds for any further argument and briefing. Also for the defense, and also in briefing, we took everything word for word from their briefs and put those arguments to rest also. And now there's no further grounds for any futile rhetoric from the defense, because it's all futile. None of it makes sense or matters. You can't argue absolute supremacy or word of law. Respectfully, perjury. The honorable judge took the complaint pleadings as the answer, so anything in that complaint or the pleadings have to go with the answer, and these are also those implications alleged that must be taken as true as fact in this court, as it must. That set legal standard and met legal sufficiency. So these things are all true in fact by law, that are being pleaded by the defendant, by the plaintiff, myself, and being put or portrayed henceforth. Everything necessary to award the damages in plaintiff's favor by law, true fact, are present without delay nor confusion. Awarding damages is and are a must in this and all courts as a fair and just court. Now these words of laws provided by the Constitution, by the state, must be upheld equally. So if I were suing them, they'd have to pay me. If they were suing me, I'd have to pay them for these. Hence these different elements and the plethora of evidence in the plaintiff's hand. That being said, this being a fair and just court, it's a must, giving those things and those standards respectfully. So we're here for that order. Your Honor, we are not asking for any special treatment, circumstance, or ruling. We're asking you to uphold the laws presented by the state and the United States Constitution, keeping in mind that the defendant's blatant perjury, wasting the court's and plaintiff's time. That being said, we are asking that the order be passed on to the lower courts, in this case in the favor of the plaintiff in all matters of this case, which are and is a must by rule of law and as a matter of the law, with word of law provided, no longer delaying or denying justice to the plaintiff, but also to set no confusion for the lower courts or honorable judge. With the law of the land provided above in briefs and pleadings, there can be no other argument or outcome in the matter of Tyler George Holland versus WT8. Bill of Rights H.R. 4115 and implications alleged as fact and truth as legal standard, which the defendant cannot argue with word of law. Absolute supremacy as a must, leaving the defendant with no other option than to lie and commit perjury. These laws and standards sent this case straight to discovery. The plaintiff, with the most clear and convincing evidence and laws of the lands provided, entitle every loss and dollar amount to Tyler George Holland as a must in any matter of the law, and must be upheld in this and all courts, along with U.S. Code 26385, loss carry forward, limiting plaintiff to compensation of a year's span's worth of business income loss, February 2019 to February 2020. These being the laws of the land have to be upheld equally without arbitrary power or outside influence, as this court is fair and just, as it must be. Confusion in the lower courts and error of the law, along with blatant perjury presented by the defense saying, and I quote, WT8 never made those statements at all, also shown in this video and portrayed in court. In briefing, also pleadings in court in front of the judge, plaintiff has provided those statements in multitude and many formats. This was to confuse the courts and try to avoid compensation for damages. Deny, deny, deny. When such evidence and exhibits are more than clear and convincing as a matter of law, this being said, there's no longer a plausible argument for the defendants, nor shall the courts allow the defendant any more futile rhetoric delaying justice. Fact, all the arguments have been put to rest in briefing. Fact, also, any and all arguments placed by defendants have been taken word for word, verbatim from brief, and been put to rest or are futile to word of law, absolute supremacy, which leaves no plausible argument for the defense in any matter of the law, or this case, Tyler G. Holland versus WT8. As a matter of the law, upheld by rule of law, and this in all courts, no matter the fact or facts, though these are failing false facts presented by the defense as a matter of the law, and any court added perjury, opening this case to summary judgment as a must, upheld by rule of law, awarding damages to the plaintiff as it should to the fullest, but limited by U.S. Code. Fact, this is stated by the Constitution and rule of law with absolute supremacy equal to all, with the law of the land provided. Fact, there is no other outcome, and plaintiff wins as a must. This being said, we are asking for the order to be passed down to portray the following, relieving the lower courts of confusion. Favor of awarding plaintiff damages. With legal standards set, favor in all motions hereforward placed by the plaintiff. With law of the land provided and upheld by rule of law. As a must, provided the three elements which push this case straight into discovery, with a favor in motion of summary judgment and final judgment, with that the U.S. 26385 U.S. Code limitation followed to the fullest. Though with rule of law provided this is a must, with knowledge of perjury and unwillingness to settle, this is more than justified in this in all courts. Plaintiff and pro per Tyler Holland is asking for this order with the power of the higher courts, and is justified by law, word of law, as a matter of law, upheld by rule of law, in this in all courts under the United States Constitution and under state law or ruling. Fair and just as it must be. Provided word of law, law of the land, to be held equally for all, with absolute supremacy, absent of arbitrary power or outside influence. Following of rule of law is a must. So are the following requests respectfully placed to the Honorable Judge. Once again, we're asking that the order be passed down to no longer delay or deny justice in awarding the damages to a plaintiff. Thank you.